Supreme Court of India. Shiv Prasad Semwal vs. State of Uttarakhand and others. Decided on March 19, 2024. 2024 SCC Online SC 322. Facts of the case. Respondent number 3 Shri Rajiv Savara filed a complaint alleging inter alia that he owns land. He had formed a trust by the name Savara Foundation, of which he is the founder, also chairman of the board of trustees. It was alleged in the complaint that in order to blackmail the complainant, the accused named in the aforesaid FIR, acting in collusion, published a news article in the e-newspaper, Parvajan, edition dated March 17, 2020, wherein it was portrayed that the land on which the foundation stone was proposed to be laid was government land which had been unlawfully occupied/encroached upon by the complainant. As per the complainant, the act of publication of the mischievous and malicious news article by the accused FIR under Section 153A, 500, 501, 504 read with Sections 34 and 120B IPC was registered. High Court dismissed the criminal writ petition. Findings of the court. The entire case as set out in the impugned FIR is based on the allegation that the Facebook news post uploaded by one journalist Mr. Gunananjak Mola was caused to be published on Parvajan news portal being operated by the appellant. From a bare reading of the language of Section 153A IPC, it is clear that in order to constitute such offense, the prosecution must come out with a case that the words spoken or written attributed to the accused created enmity or bad blood between different groups on the ground of religion, race, place of birth, residence, language, etc., or that the acts so alleged were prejudicial to the maintenance of harmony. There is no reference to any group or groups of people in the said article. The publication focuses totally on the complainant imputing that he had encroached upon public land where the foundation stone laying ceremony was proposed at the hands of Honorable Chief Minister of Uttarakhand. Apparently, the post was aimed at frustrating the proposed foundation stone laying ceremony on the land, of which the complainant claims to be the true owner. The post also imputes that the person who was planning the foundation stone ceremony was an enemy of mountains and had no concern with the well-being of the mountains. Words have no connection whatsoever with a group or groups of people or communities. Hence, the foundational facts essential to constitute the offense under Section 153A IPC are totally lacking from the allegations as set out in the FIR. There is no allegation in the FIR that the accused tried to extract any wrongful gain or valuable security from the complainant on the basis of the mischievous/malicious post. Are of the firm view that allowing continuance of the proceedings against the appellant is nothing but gross abuse of process of law, because the allegations as set out in the FIR do not disclose necessary ingredients of any cognizable offense. Hence, the impugned FIR and all proceedings sought to be taken against the appellant are hereby quashed and set aside.